Today's presentation is about fundamental breach. This will again be run as an Ignite demonstration where slides have approximately 15 seconds to run. Unfortunately, with the mixed format, the slides do not auto-advance after 15 seconds. The doctrine of fundamental breach is dealing with something where something breaks in a contract that goes to the very root of the contract. So something fundamental to the reason for having a contract. And the concept of fundamental breach basically says that if you have an exemption clause in your contract, but you break the very nature of the contract, that exemption clause does not provide you protection. The concept originated with Harvart's plasticine versus Wayne Tank and Pump in the 1970s, where Wayne was requested to provide a stearine wax storage tank for Harvart's plasticine. The pipeline was then required to carry the wax from a storage tank through the factory, allowing the plasticine to travel in a liquid state through the system. The contract covered the design and construction of the storage tanks. The pipeline to carry the wax also had a heating element, and that was covered in the contract as well. The contract stated a strict liability of limited to £2,300. When the system was first used, the pipe that provided the wax warped, cracked and broke, the wax spilt on the floor and set fire to the factory, resulting in complete destruction of the factory. So clearly this dealt with the fundamental reason for having the system in the first place. The judge decided that the design was so unsuitable that the contract was actually breached. So that £2,300 limitation did not apply to this situation. And the court awarded £170,000. So far higher than the original liability limitation, but basically covering the cost of replacing the factory. This was nonetheless quite controversial, and 10 years later it was challenged in Photo Production versus Securicor. Photo Production had hired Securicor's security guards to guard some of their warehouses overnight. The Photo Production warehouse was empty and cold in the middle of London, and one of the security guards thought it would be a good idea one evening to light a fire to try and keep warm. The security guard successfully created the fire in some drums that were in the warehouse. However, he unfortunately didn't notice that he'd actually set light to the warehouse, and in fact, the whole warehouse burnt down. This led to £615,000 worth of damage from a company that was meant to be protecting the warehouse from vandalism or other effects. Securicor had some very specific wording around exclusions. In particular, if an employee did something wrong that could not have been foreseen or avoided by due diligence on the part of Securicor, they are not responsible. And they also had a limited liability where they were not entirely exempt from the first clause. The lowest court decided that those exclusions should hold where they were clearly worded. This turned into a case that went to many different levels, so that went to appeal. At the Royal Courts of Justice, Lord Denning overturned that initial decision by saying that the fundamental breach rule applies and that this dealt with the fundament of the contract, therefore the exclusions could not hold. This finally ended up in the House of Lords, the highest court in the UK, where Lord Wilberforce turned around again and said the initial statement of the clauses was clear enough, and therefore both parties entered into accepting those clauses. And so the idea is that fundamental breach can only be found if you examine the reasonable intentions of the parties at the time of the contract. And it was clear what Securicor was reasonably intending at the time and what Photo Production were accepting. Fundamental breach was effectively laid to rest in 1989. Syncrude wanted to buy some gearboxes from Hunter Canada, who had some gearboxes they were going to provide as is with no guarantees at all of their fitness for use. When the gearboxes actually turned out as unfit for use, Syncrude tried to pursue Hunter. However, the limitation clause was very clear, and it was decided that the limitation clause was valid if the language is drafted sufficiently clearly. Fundamental breach nonetheless came back in 2010 in a case between Turcon and British Columbia. British Columbia had requested a bid for building a road, Turcon had bid on the work, and British Columbia ended up giving a contract to a company that did not comply with the bidding terms. British Columbia had specific clauses in their RFP saying nobody could pursue them in the case of a failed bid. However, Turcon pursued British Columbia for fundamental breach because they had accepted a bid that didn't meet the conditions. In responding to the case, judges came up with a three-step test. The exclusion clause that is defined in the contract may or may not apply to the breach. If it does apply to the breach, but it's unconscionable, it's unreasonable at the time of contract, it's invalid. And finally, if it is valid, is there a higher reason as to why it should still be refused? In the case of Turcon, the exclusion clause didn't apply because British Columbia wasn't in a position to contract with the party that actually didn't meet the initial terms. Therefore, the contract was thrown out and British Columbia was required to contract with Turcon. So fundamental breach is an example of how law evolves over time. Harbert's introduced the doctrine of fundamental breach. Photo production overturned it, saying that the reasonable intention at the time of contract does actually matter. Hunter Engineering then upheld exclusions if worded clearly, and Turcon defined the new Turcon test. Does the exclusion apply to the breach? Was the exclusion unreasonable, unconscionable? And if the exclusion was still valid, is there still a reason why public policy should actually consider throwing it in? And so the concept has clearly evolved over time. Now, it's worth stating that if there is no exemption clause, then fundamental breach doesn't apply, because there is no protection from such a clause that you need to try and overturn.